Okay, everyone, we're back on record here under the hearing. We're going to move on to item number 8, a petition for Pocahontas Gas LLC for pooling under Oakwood Coal Bed Methane Unit 2, Unit E37, docket number VGOB 25-07154316. All parties who wish to speak to this matter, please come forward and identify yourself.
Mark, you're still on mute.
I have that problem a lot. Mark Schwartz and Kelly Berry.
You may begin, and again, if you can incorporate as much the prior testimony, it would be appreciated.
Absolutely.
Absolutely. In fact, I'm going to remind everyone that we agreed with regard to the hearings that we had in February that we were going to incorporate our witnesses' testimony and exhibits. So I'm not going to be calling Mr. Ball again on costs because, you know, he's already testified that it was a cost estimate for these units. I'm not going to be calling Mr. Braden, who's got his testimony in with regard to the estimates with regard to gas content in the panels. And we've given you Jonathan Belcher's example of how we allocate production back to the individual units. You've heard that a number of times, including in February, so I'm not be calling him. So I'm just going to ask questions of Kelly. To some extent, I can incorporate some of her testimony. So I'm going to try and move through this with the goal that we finish today. And with that said, Kelly, could you tell us your name again?
Kelly Berry.
Okay. I would like to incorporate your testimony with regard to who you work for and your job title and so forth from your prior testimony. Can we do that, Mr. Chairman?
Yes, so incorporated.
Okay. You have the applicant here is whom?
Pocahontas Gas LLC.
Okay, let me get that up. What did you do to tell people that we were going to have a hearing today?
We mailed a copy of the petition application to all owners by certified mail with return receipt requested and published in the Bluefield Daily Telegraph.
Okay, and have you provided copies of your proof of publication and your certification with regard to mailing to the division?
Yes.
Do you want to add any respondents today to the list of people that you want to pool?
No.
Do you want to subtract any people? Do you want to dismiss anybody?
No.
Okay. And this is an application to pool under Oakwood Coal Bed Methane Gas Field 2.
Yes, it is.
Okay. And the estimate of allowable costs you've provided at paragraph 9 of your application, which is page 2, is what?
$454,784.52. And those are the allocated costs for 19 East Panel.
Okay. And we previously testified when we were here in February with regard to why we did not include the 20 East Panel, correct?
Yes, we did.
And to summarize your testimony, just to remind people, it was we didn't feel that the panel dimensions were sufficiently ascertainable and the plan wasn't ascertainable, so we weren't making a guess as to those acres, correct?
That's correct.
Okay, and Mr. Ball also testified with regard to that choice, as I recall. Do you remember that?
Yes, he did.
Okay, moving on, we have an estimate for paragraph 8 of on PDF page 4, your estimate with regard to the range recoverable reserves in the 19 East Panel from Mr. Braden is what?
12 million MCF P10 to 5 million MCF P90.
Okay. And Mr. Braden testified with regard to that and also with regard to the 10% and the 90%. Do you recall that?
Yes.
Okay, moving on, you have a plat, which is certified, and you have a certification with regard to the acreages, and that's at page 7, correct?
Yes,
Okay. You have provided an Exhibit B. What is that?
that is a list of all of the owners and claimants within the unit.
Okay. And moving on, then we have an Exhibit B3. Why do we have that?
The Exhibit B3 lists all of the unleased owners and claimants within the unit.
And there's only one, correct?
That's correct. Buchanan Energy. Yes.
Okay. And Buchanan Energy, their interest in their division of interest in the 19 East panel, apparently there are 3 tracks that they have, right?
Yes.
What is their division of interest associated with each of the 3 tracks?
Tract 2 is 0.0011%. Tract 3 is 1.482%. And tract 4 is 1.8504%.
Excuse me, was your question as to the panel percentage or the unit percentage?
The panel. That's what they're going to get paid on. Did you understand me to be asking about the panels, Kelly?
Yes, that was the information I provided.
Okay. PDF page 13 is our Exhibit M, and walk us through that.
The Exhibit M reflects the allocation across the 19 East panel of each unit that bisects that panel. It represents an estimated 14 wells to be drilled, gob wells to be drilled in that panel. The average gob well cost per well. You multiply that number by the number of wells to get the total cost. Then you apply the allocated percentage of each unit to the panel to get to the cost allocation for each unit to the panel.
And here we're talking about E37, and you've extracted that and highlighted it in yellow at the bottom, right?
Yes.
Okay. PDF page 14 is Mr. Ball's estimate, which we've seen before, right?
Yes.
And then you have a PDF page 15 is a plat, which goes to the barrier, the 200-foot solid coal block north of 19 East, but we have not mapped to panel 20, correct?
Correct.
Okay. And then we've provided a proposed order for the board to use in the event they grant this application.
Yes.
See if there's anything else. Okay. Couple more questions. What is your recommendation with regard to royalty provisions, bonus and term for people who might be deemed to have been leased?
Royalty provision of 1/8, and as far as bonus is concerned, $5 per acre per year for a 5-year paid up lease.
Okay. And if the board were to grant our application for a pooling order here, if you combine that order with the interest that we have acquired by lease or purchase, is it your opinion that the correlative rights of all owners of coal bed methane would be protected?
Yes.
And along those lines, it looks like there is no Exhibit E so that suggests that there's no requirement of escrow and everybody could be paid on a monthly basis.
That's correct.
Okay. And is it your view that developing this unit as a GOB gas unit is a reasonable way to develop the coal bed methane in the unit?
Yes.
I think that's all I have, given the ability to incorporate testimony, Mr. Chairman, so I pass at this point.
Mr. Schwartz, cross-examination, Mr. Pruitt, Ms.
Yes. Tom Pruitt and Jason Davidson for Buchanan Energy record. Hello again, Miss Kelly.
Hello.
We've talked a little bit earlier today on F-36. I'd like to incorporate your answers, Mr. Chairman, and my questions that I asked Ms. Kelly earlier into the testimony for today. And I have just a few more questions for you, Ms. Kelly. Now, not talking about short hole gas, but gob gas and the panel. And it's been said more than once today, I think, the Coronado basically picks the well site. Would you agree with that? When we select the well sites within the panel?
Yes.
And we've discussed the fact that Buchanan Energy is the owner of gas and coal and surface. I'd like to direct your attention to the demonstrative, the diversified rather, Exhibit 14 that was submitted earlier. It just happens to show the short holes, but I'm not focusing on the short holes. It's just a real clear exhibit to look at.
Sure.
I think the board has that. Do you have that in front of you?
Yes, sir.
Okay. And we're looking at 37E. Would it surprise you to know that Buchanan Energy surface ownership in that unit roughly coincides with the pink area in that unit?
That appears correct. Yes, sir.
And so it's fair to say that forced pooling does not give you any rights over Buchanan Energy's surface, does it?
It does not.
Not you personally, your company. I'm sorry.
Yes, sir.
As contractor for the coal company, Pocahontas can drill the ventilation wells in that unit. But we've discussed the fact they don't have the right to produce the gas on the Buchanan Energy surface. Is that your understanding?
Yes, it is.
And that right is vested in Diversified, isn't it?
Yes, sir.
And if your company is to get onto that surface area to produce gas from those ventilation wells, they'd have to negotiate with Diversified, and Buchanan Energy would have to give consent. So the people that your company would have to deal with are on this side of this table today, aren't they?
Well, I'm going to point out by objection that you keep saying ventilation holes and there aren't any, and we haven't drilled any.
I'm not sure how relevant that is because we're looking forward to the gob gas panel.
If it's not
Gob
relevant,
gas wells.
excuse me, if it's not relevant, why are you asking the questions about ventilation holes?
Because that's the limit of Pocahontas gas ability to be on Buchanan Energy's surface.
Well, so what? I mean, you know, we're not drilling ventilation holes. We're going to be drilling CBM wells, which are permitted as wells. Ventilation wells are permitted through the coal side. You know, we're going to have CBM wells And, you know, you're talking about the surface location is not where Coronado is telling us they need the well. They're telling us where they want the bottom of the well to be, not where the surface starts. So, I mean, the fact that the surface may be over the where Coronado wants the well doesn't mean we can't drill a deviated hole to get there. So ventilation holes, I don't know why you're talking about that.
Well, I guess our point is surface rights. And the point I'm trying to make to this board is the limitation that Pocahontas has in being on Buchanan Energy surface.
And she's already told you we don't have rights to be
And
on the surface, but you're arguing we can't drill a diverted hole to be off the surface and get to the bottom location that Coronado wants. Is that what you're saying?
No, not at all. I'm exploring the limitations of the rights, and I have several questions pertaining to that.
Go ahead.
Ms. Berry, if the well is located on Buchanan Energy's surface, the ventilation well.
Well, same objection.
Your
You don't
company-
have ventilation wells.
Dom wells,
All right,
not ventilation wells.
okay.
Thank you.
Your company cannot collect gas from any well on Buchanan Energy's surface, regardless of the type of well, can it?
Correct.
Your company cannot maintain a production well that would be on Buchanan Energy's surface, can it?
Correct.
So in no respect can Pocahontas invade the surface that is shown in pink on 37E, that particular unit. Is that correct?
Yes, sir.
And according to Mr. Schwartz, you're only allowed to offset drill if that's what your company chooses to do.
Not saying it's the only thing, but it's certainly an option. We could ask Coronado to relocate wells to accommodate us, but you know, we've drilled a ton of deviated holes and presumably we'll continue to do it. It's an option.
To get on Buchanan Energy's surface, you must have consent from Diversified or Buchanan and Buchanan Energy. You understand that?
Yes,
I would
sir.
object to Diversified consenting. Diversified doesn't own the surface. Why are they in that question?
Diversified has the sole exclusive right to drill and occupy the surface under the lease. And
So
so
you can argue that. They don't own it.
what percentage did you say 37E is occupied by Buchanan Energy?
The individual unit,
Yes. I have 77.4% of that unit. Is that
yes, sir.
right?
Of that unit, yes.
And 77.4% of that unit is the surface is owned by Buchanan Energy.
Yes, sir.
That's all.
Nothing further.
Ms. Berry,
Yes, sir.
there is a operational frac well on 37E. Is that true?
Yes, there is.
Is that Rogers 426?
Yes, it is.
And it is currently producing gas, correct?
Yes, sir. To the best of my knowledge, yes.
And that's a frac well operated by Diversified.
Yes, sir.
And it's situated right in the middle of the longwall panel. Isn't it?
Let me go back to my mind map.
Longwall panel 20, just for clarification, not 19. But
Right.
their application is 19.
He's just.
Yes.
Yeah, if I said 19, I meant 20. I'm sorry.
You didn't say either one. That's
Okay. Yes, sir, 20. And so have you in your application designated a single location for a gob well in 37E?
No, not at this time.
You don't know where any of the gob wells will be?
Since this application was filed, there may have been locations developed, but at the time that it was filed, that was not information available.
So since you filed your application, you've been in contact with Coronado and they have indicated to you proposed gob wells in 37A. Is that correct?
I'm not sure. I have not been in contact with them.
Well, just a second ago, you said there may have been communications. What were you talking
There
about?
may have been with our
Do
permitting
you have,
department.
do you have reason to believe that there were?
I assume as mining progresses closer to the point in time when mining will take place, that would be a logical conclusion.
I'm just trying to, has anyone suggested to you, intimated to you, told you, hey, Coronado's let us know where where some of the gob wells are going to be? I mean, do you have reason to believe that's happened?
Not to me personally, no.
Okay, well, who did they talk to?
That would be our permitting and land departments.
And how did you find out that that happened?
I don't know that. I said possibly.
You're just speculating that it may or may not have happened. You don't know?
I don't know.
Okay. All right. So let's assume that the gob well panel that is depicted in Diversified's Exhibit 14, the panel 20, that it gets mined. And so that the panel underlying Rogers 426, wrote it down wrong, is then situated over that panel of coal that is in longwall mine. Okay. Are you asking the board then, once that happens, are you asking the board to make Pocahontas Gas the operator of Rogers 426?
No,
Is CNX okay with Diversified continuing to operate that well after longwall panel mining begins?
I can't answer that question. We're not that far ahead, so I can't answer that question at this time.
Well, are you going to treat Rogers 426 like you have other frac wells overlying longwall panels that have been undermined before? I mean, we've run into this on a couple of prior hearings. There were existing frac wells.
Well, that would
what
be a
is it?
decision between Coronado and Diversified.
Okay.
As to what happens to that frac
But you're
well.
not asking the board to designate you, Pocahontas Gas, as the operator of Rogers 426 here, are you?
Asked and answered. She said no.
If Rogers 426 transitions into a gob gas producing well after the longwall panel is mined, such that Diversified then is operating a gob well, is Pocahontas Gas going to be able to work with Diversified and cooperate in the joint operation of gob wells in that unit, assuming that Pocahontas Gas gets designated as an operator here?
I have an objection to that question. It says, assuming it transitions from a frac well to a gob well, that doesn't happen. And you've got the division You could talk to Mr. Skarupa or Mr. Boyd, and they can tell you what could happen, but that's not something that happens. It does, there's no transition.
Okay, well, that's exactly the opposite of what we learned last time, Mr. Schwartz.
Well, presume if what happens normally in the past, that well will be plugged at some distance above the Pocahontas 3 seam. And in theory, it could continue to produce frack gas. So, I mean, but this is theoretical. I don't know if Coronado's going to want them to plug the well entirely, if Coronado's going to, I mean, I have no idea. But that could happen. You could still be there producing frack gas, but not from the Pocahontas 3 seam, which was now producing unsealed gob gas.
Going to move to introduce some transcripts from the board's prior hearings. This is marked as Pocahontas. Let's exhibit number 13. In response, Mr. Schwartz, let me read to you and the board some excerpt proceedings from April 20th of 1993. Here's
What year?
1993, back in your time.
Okay, cool.
This is the chairman. That's, to me, one of the most fascinating and perplexing aspects of this is that the well that shifts from the allocation formula shifts from the mine through, because it goes just from an acreage basis to a panel basis. It's in fact correct. Asking about this transition of frack wells to goblins. And the answer was right. And the person that answered that question right was Mr. Schwartz. Right before that, the question from the chairman of the board was, there was a Miss Evans, and she said a frack well changes over during mining through isolation of a pan. Changes over to a gob. That was on page 17.
Back in 1993, I was representing, I think, Oxy USA. Although it's possible by that point in time I was representing Consol. But the practice back in 1991, 2, and 3, we were drilling frack wells out ahead of mining. And we were fracking those wells in the P3 seam. And we were, instead of drilling gob wells, we would plug those wells during mining, and then we would go back in and use the same well bore to produce gob gas. My client is no longer doing that. We're not drilling frack wells ahead of mining. Coronado is not asking us to do that. They are asking us to drill gob wells that will produce after mining. So you got a frack well out here, and you could plug it for mining, and then I don't know what Coronado's going to want you to do, or what the division is going to want you to do, but there's no automatic conversion from a CBM well to a frack, from a frack CBM well to a gob gas well. And the other problem you've got is, you got Buchanan to deal with as well, but there's no conversion. And we're not doing what we used to do. In 93, absolutely. We drilled primarily frack wells, fracked them into P3 seam, plugged them, mined through, and reopened them and produced the gob from that. And now we're not out ahead fracking.
So, Mr. Chairman, this discussion on page 17, this was in regards to the open. So I think it would be instructive for to review these at some point. But these Oakwood rules haven't changed since this time. And it's clear from the reading what Mr. Evans said. Frack well changes over during the mine through the isolation that is exactly what your Oakwood orders say. They say, once a frac well is isolated in a longwall panel, it then automatically becomes paid out, not under the Oakwood, but under the two. And talked about this last time we were here. It may have been off the record, but I had a pretty clear understanding that's what we all decided was going to happen. So, that's what Mr. Schwartz thought back then, but I know he's representing a different company. So,
Okay, so we're having a lot of discussion here, and I'm not sure what the question was at this point.
there was an objection to the question, and that's what got us going. But the question is to Ms. Berry, if this well continues to produce after the longwall panel is mined under it, you're not asking this board to make you Pocahontas Gas the operator of that old frac well, right? You're not going to ask for that, are you?
No, we have not.
Okay. And if it continues in production, that Rogers 426, but it's now situated over a longwall panel that has just collapsed, and it's now producing gob gas. You're not going to object. Diversified continues to operate that well and pay royalties on the gob gas that well produces under the Oakwood 2 formula. Not objecting.
I can't make any speculations on what's going to happen down the road. That's in a completely different area
And a different area from what?
than the application that we're here on now.
Do you know what should happen to that well if it begins to produce gob gas? And Diversified continues to operate it and pay royalties under the Oakwood 2 formula. Do you have a sense, having done this for so long, and being a permitting vision of interest person in your career, what should happen? What do you think should happen?
A gob well should be allocated to the panel that it's in.
That's how the interests get allocated. Now I'm asking you about who the operator of that well should be.
I think a more appropriate question is, Ms. Berry, in the past, have there been two operators within the same unit and within that longwall panel? How has that been handled? Is that what your question is in reality? Has this ever happened in the past, I guess?
That'd be good to know, but I guess that only gets us so far, right? Because we're now facing where that's going to happen. We have different companies. We're going to have this well that's.
In other words, the Oakwood 2 rules did not contemplate this. Is that a fair statement?
I think
From a different operator standpoint,
yeah, they didn't specify.
I don't think it is specified. I think it's silent.
I think back then you had a couple big players and there was no crossover between them.
Right.
So now you're in a different land. But
Well, if you're done, here's something that nobody has discussed. I haven't looked at the order of the Rogers well that we're talking about, but I assume it was a pooling order and it pooled under Oakwood 1. So Diversified inherits that well, and it has the ability under that order to produce frac gas, okay? Under Oakwood 1, which says it doesn't apply to gob gas. So to get where Mr. Street is suggesting he wants to be, Diversified would have to file a permit modification, come back in front of the board and say, we have this Oakwood 1 well that's been producing frac gas, and we want you to allow us to convert it to an Oakwood 2 well, or a combination, because it's still probably producing frac gas. And we want you to allow us to do that. So it's going to, it's not they're producing frac gas under an order that doesn't allow them to produce gob gas. So it's going to require them to come back to this board, if that ever happens, and say, here's what we'd like to do, or what do you want us to do? That's what we're talking about.
Well, that ignores the clear language of the Oakwood, okay, because that's not what they say. And you may recall, Mr. Schwartzman, we were here a couple months ago, we discussed this in the side room, and we learned that they do convert over automatically, and there's really no system to monitor how that happens right now. But here's what the Oakwood 2 order says, and it's right on point. It says for gas from any well, such as a frac well, located in a longwall panel, after actual commencement of the coal operations by the driving of entries, isolation of the longwall panel, the amount of gas produced from such a well will then be paid out according to the Oakwood 2 order. But prior to that time, it will be paid out under the 80-acre drilling unit under the Oakwood 1. So the Oakwood 2 order and follow-up orders, they contemplate and address this situation. You can have a frac well. It gets, once the panel is isolated, and then the gas from that well is paid out under the Oakwood 2 form. The practical difficulty is for that frac well, how do you determine who to pay? And yes, you probably should go back and figure out who the different interest holders are. But that doesn't change the fact that well, it just transitions to a gob well. It's still our well, so we're going to be producing gob gas. And so that's why my question was to Ms. Berry. Was her company basically trying to take that frac well that's going to be a gob well away from us in this application? And I think she said no.
She's repeatedly told you that she doesn't anticipate we're going to want to be the operator. But I will also point out some language in the Oakwood 1 order, which says this order shall not, however, apply to coal bed methane wells drilled into the gob area of any working mine or any other conventional gas well. And I guess all I'm saying is, if you get a pooling order under Oakwood 1 and you claim you want to produce under Oakwood 2, you need to make it to the board. That's all I'm saying.
Well, you're talking about a different issue than we're talking about. We're talking about who gets to keep this well.
That's
Yeah.
your argument. No, I'm not. I'm saying if they want to keep it, come to the board.
If we want to keep it, we have to come back to the board. Is that what you're saying?
If you want to produce gob gas from a Oakwood 1 rule, an Oakwood 1 order, you need to go back to the board and say, we're going to convert this to a gob gas well. We want to produce under Oakwood 2. That's all I'm saying. You disagree, you say it's automatic. I'm saying you got to get back to the board because you got an order that says you can produce frac gas.
How do you explain the Oakwood 2 order itself, though? And I know you've read it. It talks about this transition from a frac well to a gob well and different formula. It doesn't say anything about going back, repooling. Well, it just says once the panel is isolated, you pay different.
Well, the Oakwood, let's stay with this because I think you're really in an area that we do need to talk about. Let's assume that you want to convert. Let's assume that's mine through, and you're saying, okay, we've transitioned now and we can produce gob gas. What notice are you going to give owners of their change in their royalty interest? Because now, if you're producing gob gas from a panel, their division of interest is going to be in the panel rather than in the Oakwood 80. You're going to have to prepare and produce, new exhibits B3 if they're still escrow. I mean, the idea that you could just do this on a pooled unit without coming back to the board to validate the division of interest, it's just mind-boggling to me. I mean, have a very specific order telling you how to pay royalty, and you're changing the kind of well you've got and the way you're going to pay people and allocate the costs, and you don't have to come back to the board and you don't have to give notice to the people you've pooled in the past. I mean, I just don't buy into that. I hear what you're saying. We're in a disagreement. I say you need to come back to the board. You say you don't. I mean, I guess at this point it's a punt.
Well, you may remember, and maybe we could get Mr. Boyd to step back up and discuss this. But 2 months ago when we were here, we learned that as I understood it, there is an expectation that an operator will figure out who to pay correctly. The board doesn't presently monitor that, but that's how it has to work. You're talking about, what you're talking about is an accounting issue. Who do we pay? Who is on the register? Who's on the list? What are the addresses? What are the fractional things? And yes, that has to be figured out. What I'm talking about is who has the right to produce this frac well even after the panel is removed. The right to do that is under the Oakwood orders. That's why the Oakwood order that we've talked about before, which ends 0349, it specifically says that this is the way it works. It says in conjunction with the Oakwood 1 order. You have to read them together. That's not my language. That's the order's language. In conjunction with the Oakwood 1 order, here's how it works. The following method shall not apply to wells producing under the Oakwood 1 order unless and until the panel is isolated. So this is a progression. This is contemplated by the orders themselves. How we do it internally with the board, who would, what gets reported or the listing, that's an accounting issue. I'm talking about the substantive rights of the parties. And so I'd like to get clarity from Ms. Berry as to whether it's her position that we're going to lose. Are we going to lose our right to produce gob gas once this Rogers 426 well starts producing gob gas that is released when the panel goes? That's my question.
The answer is, what's the board going to tell you when you try to do that? If you come in front of the board and say, in a pooled unit, trust us, we'll do the math and we'll pay the people and we won't file any documents with you to tell how we're going to pay it. I mean, we file pages of exhibits B and B3 where we go through everybody's interest, their acreage, their percentages. And what you're saying is, well, we're going to convert this well on our own to a gob gas well, and we're not going to use the percentages that were in play and everybody knew about when this was originally pooled, and you just trust us because it's just accounting and we'll do it right. And I don't buy into that.
So I think the reverse question of this, so you've making the assumption that Pocahontas Gas is going to prevail on their application. If Diversified prevails on their application, what is your plan to do with that Rogers well? Do you think you need to come back in front of the board to clarify that?
We will prevail on pooling this unit. We'll have all the percentages in the names, and once that panel is isolated, we will then immediately start paying under the Oakwood 2 methodology to the interest holders as they're established in this order. So the problem will be solved. Yeah.
But those same percentages are basically being by both parties here today, in theory, right? They should be very similar. They should be very similar.
She'll know better. I think they may.
I mean, the percentages are there, so the information is available to make the payment. So I don't know why we're arguing about this at this point.
Well, I don't. Maybe Mr. Right. Maybe it's more a question to the board. But how is that going to work on these wells?
Well, I think if we take your position that the Oakwood 1 and 2 orders contemplate this, that's the way it works. Regardless of who the unit operator is, you're still the operator of that well under the Oakwood 1. You would just transition to the Oakwood 2 payment. The information is available to you to make those payments.
And then at the whatever the board's direction is, we've contemplated just then going back and following it.
And I think procedurally, if we need to put something in place, the board could do something on their own motion to make that happen. on this specific case. It's going to be a very specific case. This is probably only going to happen in a handful of situations based on, so, one and two. So let's not get caught in the weeds here.
Well, the only
If we
other
want to
issue,
rewrite a bunch of rules, that's where we should have been 6 months ago. If we wanted to rewrite the rules 6 months ago, we could have gone down that path. This board chose not to go down that.
I didn't mean to suggest rewriting rules. Guidance is all that would be
Well,
required.
that's our guide. If you can take that as guidance, I think.
But we would, for our purposes, we would be glad to come back to the board after whatever happens. I mean, obviously,
Okay.
we think we.
And I think that's the prudent thing to do. Protect
We
yourself
want
and
to restate who the people that need to be paid are after that longwall panel.
Right.
That makes a lot of sense from an internal standpoint. That way Brad's not wondering, well, are these people paying correctly now on this new gob well that was a crack well? Then you have documents of that. That seems like the smart thing to do. That's, But
the board operates under a lot of faith that the operators producing the gas in this field are doing the correct procedures to make this happen. We don't go back and look at every single, nobody's reviewing anybody's payments.
my client has not done it wrong yet.
well, the last thing.
We would like the chance to do it.
Understand?
One more thing, if you convert this to a gob well and you're producing gob gas, people have a right to participate. It's just, how are you going to do that without going back to the board? You've changed your method of production, you've changed the cost that could be allocated, and you're not giving the people a chance to participate. It's not that simple.
Again, that the Oakwood 1 and 2 rules did not contemplate, correct? It doesn't spell that out with clarity.
Correct.
So, again, I think this board's position would be, and speaking for the board, maybe out of line, but I think we would expect someone to come back and bring forward that change and how this payment was going to be done for the full, regardless of which.
Yeah, well, to me, a lot of that makes sense. For the record, I need to be clear though, because I don't want to get ahead of us. It is our basic position because we're already the operator of the unit.
Substantial.
So it would be smoother if we're in, then we wouldn't have to worry about that issue.
I agree. I think we've covered that pretty well. Let's keep.
Yeah, well.
Did you have any more questions?
Problems. Okay, I know that you and Mr. Pruitt talked about the surface quite a bit, so I don't want to belabor that with you. But when I look at E37 and I'm looking at Exhibit 14 now, which is this plat right here. Do you have that in front of you, Ms. Berry?
Yes, sir.
Okay, so just isolate your vision on E37. Part of it's red, part of it's white, right?
Yes, sir.
The red part, that's us, that's Buchanan Energy. That's what percentage do we have according to your numbers?
Of the total unit,
Yeah, just of the unit, 37, E37.
I'm sorry, let me scroll back. I believe we said 77.4%.
Okay. And the white part of that unit, that's not, your employer doesn't control all of the white in E37, right?
Yes, we do.
So if we add up your interest and our interest, we get to 100?
We should.
Is that right?
We have all of the remaining tracks, other than the Buchanan Energy tracks, leased in that unit.
Okay. So if you look at just the section of the longwall panel in E37, have you done a calculation as to what portion of panel 20 you guys control that is within E37, just the long wall panel now, not the whole unit.
Not for panel 20,
I think we've
Only-
covered that
only
they
for
not
19.
addressing panel 20 at this time because of
Yeah,
potential changes to that information.
it's, okay. It's pretty small though, right? I mean, just I'm eyeballing it, but it's a tiny little triangle, right? Down in the southeastern corner.
Yes, it appears to be.
Okay. So do you have any, so basically Buchanan Energy owns virtually all of the surface area of panel 20, the panel, in that unit. So E37, panel 20, Buchanan Energy owns virtually all of the surface of that section of the panel, right?
It appears to, yes.
So do you have any, I mean, we talked about infrastructure earlier and there were questions about what sort of plans later, infrastructure, how you're going to get the gas. Do you all have any plans in terms of creating some infrastructure on the surface of that section of panel where you don't have any property right, any surface rights? Do you have any plan whatsoever on how you're going to get a gob well in there, much less 6 of them? Or are you just going to
That-
figure that out later?
That's beyond the scope of my ability to answer.
Does your company have any witness today that can answer that question?
I don't know. Mark?
Well, I mean, we're currently in negotiations with your client. Your client probably knows.
Which client are you referring to?
Diversified,
Oh,
diversified.
So just let me ask this question to move this along. Both applications here on this competing unit have 14 wells that have been provided by Coronado to be drilled within this panel. Does anybody have a map that shows the proposed bottom location and top location of those 14 wells? Or has that not been developed to this point? We just know there's 14. I don't know what Coronado's provided to both parties. That's my question. Do we need somebody from Coronado to rectify this? If that's the question that needs to be rectified, I don't know that it's pertinent really here, but
Mr. Chairman, I think it is pertinent. We've talked a lot about gob wells and frac wells,
I understand.
and I mentioned vent wells. Now, if you think about what Pocahontas,
Let's wait just a second. So at this point, your application has not proposed any wells, any gob wells on this unit, correct?
I'm sorry.
Your application on this unit, Pocahontas has not proposed any gob wells today on this application. Typically, we see those on most applications where you're going to put gob wells, but in this one, in this case, there are none proposed. Is that because don't know where they're going to be or there's not going to be any?
Well, I think Kelly has told you that at the point in time when she filed this application, she didn't know where they were going to be. But obviously the plan is to drill the number of wells that we've talked about. If we have to do it on a deviated basis, we're going to do that. So the answer is we anticipate spending the money that we're proposing in Exhibit M to drill those wells.
So that's for panel 19, correct?
For 19 only.
Correct.
We're not making any projections
They're
with
not
20.
they're not making any projections on 20 at this point in time. We're only
And
talking about
whoever
20.
winds up in 20 and whatever that is, there's going to be a trip back. But, to put this in perspective, Mr. Ball testified that at the earliest, panel 20 mining is not going to start until the first quarter of 2030.
Okay, well, I hear Mr. Schwartz saying we'll figure it out, but what I'd like to hear is a witness saying there is some feasible way to drill a hole. You're not just trying to pull the part of E37 that is in panel 19. You're here today trying to pull E37 insofar as it covers panel 19 and 20. You're not limiting your pooling, are you, Ms. Berry?
Well, I can answer that. We have proposed nothing with, we have proposed nothing with regard to panel
This
20.
minute, Mr. Swartz, hold on. He's asked your witness a question. Let her answer the question.
I'm sorry, can you repeat the question?
Yeah, it's the application that you're on here on right now for E37. If you're successful and you pull E37, you're gonna get an order that pulls all of E37, not just the portion that encompasses panel 19, right?
Well, if any plans were made to develop that unit beyond 19, we would have to come back before the board.
But you would agree with what I said, though. You're pulling the entirety of E37 today. I mean, that's what you're asking.
As it relates to the portion that is located in 19 East Panel.
Okay, and so when you sent out notice on your application, none of the people that you sent notice to, they don't know anything about how many wells you're gonna put in the 20 panel,
No,
and they don't know what that's gonna cost, right?
no.
And so how are they supposed to figure out what election to make if they don't know anything about your cost structure, your wells, or anything like that?
Their election would be limited to the information presented for the 19 East Panel.
Okay, and so then if you're successful on this unit and you want to come and you want to put a gob well in panel 20, you say come back to the board, are you gonna go through all this again, repool it, you're gonna send out?
We would have
notice?
to, yes. Yes,
And again, without the surface rights, they still cannot get on that property, even through another order, even this order or a subsequent order. They still would not have any surface rights on that. That's not going to change.
Well, it could. We
Well,
got 3
yeah,
years.
Yeah, so unless there's a agreement reached between
Agreement.
parties in 3 years.
Sort of
Right.
mention one,
Right.
maybe we can get back on track with that.
As it stands today, there is no agreement.
Okay,
Correct.
That doesn't, it's irrelevant to this application.
agreed. It's a distraction though.
Mr. Chairman, at the cost of maybe having you throw a shoe at me, but I would like to make this point.
Sure.
I did call them vet wells. I did it intentionally. The wells are being drilled because the coal company needs to be ventilated. Regardless of which of these competing companies get the right from forward, the coal company needs the mine to be ventilated. Now, under their coal lease, they don't have the right to give Pocahontas directions to drill gob wells on Buchanan Energy's property. They only have the right to give Pocahontas the right to drill ventilation wells.
Understand? And they wouldn't need to come in front of this board to do any of that.
That's right. And they can't come back onto the surface to hook those wells up and make them produce gob wells.
Correct.
Diversified is not entangled in that way.
Understand.
I'm simply wanting to make that.
Thank you. Let's see. So we were questioning his witness.
So I asked, a couple months ago, I asked her questions on E38 and got answers or cross-examined her. I would just ask it all that being incorporated into this case as well. I know we're doing that with everything else, including the proffers. I made a proffer about, reimbursed costs. So I'm not going to drag y'all. Although I would like you to reconsider hearing me out on that, but I suspect I know the answer. But I do need to incorporate all that.
That be incorporated into your testimony.
And then I'll close with this, perhaps. I'll try to. Is there, the last time we were here, you said y'all are not asking the board for you're not indicating to the board right now that you're going to try to use any of the gas that you produce or attribute to 37E to generate environmental tax revenues. Why are you not doing that? Why would you not want to do that in addition to the other income stream that you're going to have from possibly the sale of gas?
Those decisions are beyond the scope of my ability to testify. Those decisions are made by people higher up than me of
And
of what they want to do with the gas.
and you said last time you would come back to the board. Would you come back and file an application to amend your pooling order to do that? Is that what you envision doing if you change your mind?
If a different type of revenue stream were contemplated?
Yes, ma'am.
Yes, sir.
During all the review of everything, I ran across your well permit for vent shaft 16, not 15, but 16. And on vent shaft 16, you filed a couple of amendments to that permit. And 2 or 3 into that, you changed the designation of that well from something like, there was a description on the permit, what is the well? And it was, originally it was facilities, something, general. On the second or third amendment, you changed that and now it says environmental credits on vent shaft 16.
Are you talking about a permit or are you talking about a pooling order?
Well
Those are two
permit.
different things. And I can't speak to anything on the permit applications.
So you're not, but that's not what you're going to do here. You're not going to circle back around and just change the well permit, say environmental credit, are you?
Vent shaft 16 was pulled for a different purpose, to be a different type of unit. Which did address environmental credits.
Do you, I know we've worked on these cases for close to a year now, so I know that I know a lot more than I did. But when I first started talking to you about this last year, as I recall, you didn't know a whole lot about environmental credit revenue at the time. Now that we've been through this for a while, are you aware that your company generates quite a bit of environmental revenue credits during the normal course of business in a given year?
I've gathered that from testimony today.
That's the only information that you have before you. Is what you
Yeah, I don't look into that kind of detail.
And this may have come up already. I'm sorry. But have you done a calculation in panel? How many units are in panel 20? 8? So
We don't know.
I don't know.
is that because Pocahontas Gas does not know the stat on well panel 20?
I'm sorry, you broke up a little bit on me.
Why do you not know how many units are in panel 20?
We can guesstimate based upon maps today, but they could change in the future. The map that we have been looking at of your exhibit 14 looks like 6 units, perhaps.
And have you done anything to calculate the percentage of property that Buchanan Energy owns and the diversified leases that is contained within the boundary of panel 20 on our exhibit?
Not at this point in time, no.
Based on the map you're looking at, would you agree that it is a majority?
I would.
And you agree that E34, E35, and E36, each of those units contain or consist of approximately 80 acres, all of which is owned by Buchanan Energy and leased to Diversified.
Yes, sir.
And but by virtue of that, those are voluntarily pooled, as you have explained, right?
Yes, sir.
That's all I have.
Do you have any, redirect, Mr. Schwartz, of your witness?
No redirect. I would simply sort of say the same thing that Mr. Street was saying. I'm incorporating Kelly's prior testimony from other hearings, so I don't have to repeat stuff. And so reminding everyone that I'm including Mr. Wall's testimony with regard to Coronado's consideration of starting panel 20 much further to the east on property that is owned by Consol. Just reminding you, he testified to that in court. That's it. That's all I have.
Questions from the board of the witness? I just have one question, Ms. Berry. I don't think you all put this in your application. Do you know the acreage associated with the 19 East panel that you used to do your calculations on all the allocation?
It's not in the application, but I do have that information.
Thank you.
That is 171.38 acres.
Thank you.
You're welcome.
Okay, that concludes the testimony for docket number 2507154316. Pocahontas Gas. We'll move on to the petition for Diversified reduction for pooling under Oakwood Coal Methane Gas Field 2, Unit 37, docket number BGOB 25-1021-323. All parties who wish to speak to this application, please come forward.
Thank you, Chairman. So if we can incorporate Mr. Tetrick's testimony from earlier and testimony from Mr. Hess, and I can just focus on the differences in this application and
That'd be
quickly
perfect.
for you.
So incorporated. Thank you.
Mr. Hess. Mr. Hess, good afternoon. So we've incorporated a lot of your testimony. So we're going to move through some of the parts of the application that are different in E37. So we'll move quickly, just touch upon a few things here. So you are familiar with the application you have prepared, correct?
Yes, ma'am.
And Diversified is authorized to do business in the Commonwealth, we established that earlier, and is registered with the Virginia Department of Energy, Division of Gas and Oil, and has the required blanket bond.
Yes, ma'am.
So, looking at the amended application that we sent in for E37, this again is the type of wells we have outlined are for coal bed methane gas wells, including gob wells, short hole gas wells, and other wells within the longwall panel.
Yes, ma'am.
Okay, and we submitted, for the regulations, we noticed the respondents through certified mail, return receipt requested, and through the Bluefield Daily Telegraph
Yes, ma'am.
and provided those proofs to the board.
Yes, ma'am.
And so our percentage in this unit is, Diversified's percentage in this unit, 73.733%,
Yes, ma'am.
which means that we're seeking to pool 26.268%.
Yes, ma'am.
And this is an 80 acre unit.
Yes, ma'am.
So if we look at the plats, which are here on page 8 through 9, there is a well on this application, and that's still operating, is that correct?
Yes, ma'am.
And that's Rogers Ford 26,
Yes.
and that's a frac well,
Yes.
and Diversified is the operator of that frac well.
Yes.
Do you have any plans to plug or abandon that well?
We're accommodating mining bottom hole plug for communications coordinator.
Okay. All right, and Mr. Bailey also certified this plat as well.
Correct.
So if plan on incorporating the testimony that we spoke earlier, of the changes to the application, if that's okay, Mr. Chairman.
Yes. So incorporated.
So let's move on to exhibit B and B3. Like our prior application, we have outlined the unit holders, correct? The owners within the unit.
Yes.
There's 4 separate tracks, 2 owned by Buchanan Energy,
Yes.
which are leased by Diversified.
Yes.
And so like our prior applications, we've put across there the acreage percentage that each owner has in the unit itself, and then the percentage they have in 19 and 20.
Yes, ma'am.
And we believe the 19 panel has a 10.1% within that unit interest, and then the 20 panel is actually 14.64% in unit E37, correct?
Yes, ma'am.
How many God wells do you plan on putting in panel 20?
Panel 23.
Okay, and that's, that information was provided to you by Coronado.
Yes.
And,
You mean just for that unit?
Just for that unit.
sorry, just for that.
NE
unit.
37 unit for panel.
I apologize. Yes. In unit E37, there's 3 God wells that you plan on putting in panel 20.
Yes.
How many in panel 19 for unit E37?
0.
And that information came from Coronado.
Yes.
Do you have an idea of the location, or are they still working on the location of those God wells?
They gave a spot upon. Sorry.
And, sorry, just a second here. Do they have a projected date when they plan on starting work on panel 20,
Text. It's January of 29.
2029?
Yes.
And so you have, you stated you just got a text from Coronado, so you have a close relationship with Coronado.
Yes. Very good.
And it's longstanding. How long have you had Coronado? 25 years. Okay. So, do you anticipate that if we are making an operator of E37, that you will reach an agreement with Coronado on how to drill and produce these gas wells? Let's move to exhibit C. This is a breakdown again of the well costs, and we have the well costs as 707,000. I think 985,
707,985.
and that's for panels 20.
Yes, that's for all wells and panel plants normalized, yeah.
And panel 19, and it's a little different.
Yeah,
And why is that?
the elevation drill depth, you can see it changed between the 2 exhibits, so it's slightly cheaper for panel 20.
Right, and then those numbers are incorporated here into exhibit M, as we had spoke to earlier.
Yes.
So at the top, you have the well cost, and then that's in 19, it's about 14 wells that you anticipate,
Yeah.
correct? And then if we go down here to panel 20, you guys actually have 23 wells. Is that correct?
Yes.
Okay. So there's quite a few wells, and that's if we look at the units, how many units there are affected by 20 East?
20 east is 1. 14.
14 units, okay. So of those 14 units, it looks like D34 has been voluntarily pulled by Diversified because we own 100%, correct?
Yes,
The same as E34,
yes,
D35,
yes,
E35,
yes,
D36,
yes,
E36,
yes,
and D37.
yes.
So we have 100% ownership in 1, 2, 3, 6, 7.
Correct.
What is the total capital for panel 19? If we look back to exhibit M on page 19. Yes, what's the total capital?
10,358,481.
And what is it specifically for unit E37?
E37 is 1,049,302.09.
And at this time, I'd like to incorporate the testimony we had earlier on how an owner can calculate it.
So incorporated.
And so panel 20, what is the total capital for panel 20?
16,698,6.
And E37, what would be that?
2,443,675.89.
So all the capital is dispersed across these panels,
Yes.
And a good- and a good portion of them are 100% owned by Diversity.
Yes,
And this information of what units are being affected, that came from Coronado, your work with Coronado.
correct.
If we turn back to exhibit L, which is on page 18. This is where Coronado and Diversified expect or project the panel to move through the surface and the mineral
Yes, ma'am.
marsh. And this also was certified by Mr. Bailey,
Yes, ma'am.
as in accordance with the projections from Coronado.
Yes, ma'am.
There's not an exhibit E in our application because there's no scope required, right?
Correct.
And we have submitted a proposed order,
Correct.
and we testified earlier about the payments. Do you remember what those were?
They're going to be on environmental attributes and or commodities.
And what's the royalty?
1A, $10 per acre.
I did move through that really quickly, so let me check with Ben. What did I forget, Ben? That went really quick.
Well, Mr. Swartz may remind you of things you've forgotten.
Ben, did you have anything you wanted to add before I?
Well, I do have, you asked Mr. Hess if he had a good relationship with, Coronado, so I guess maybe to follow up on that. Mr. Hess, will you tell the board what Project Nexus is?
Project Nexus is an opportunity to utilize CMM gas in Buchanan County to lower the power costs for the region. And it's part of the DOE grant that was due yesterday. And we have a great partnership there with Coronado as well as other lucrative companies that we are very excited about.
And some is that project, it's part of the goal will be to capture gas, generate electricity locally.
Yes.
Okay. And First Funds Exhibit 11 to the clerk, move that it be admitted, but what is that letter, Mr. Hess?
Mr. Wood, support for application and this project from Mr. Steve Hicks.
He's with Coronado Global,
Yes.
and so they're backing y'all up on this project. Not
They stand to benefit from it.
anyone else endorsed you and given letters of support?
Several. We've got Virginia Oil and Gas Association, SEA, A New Climate, Pine Mountain Resources, we've talked today, Appalachian Electric Power and their regional territory. Got like 11 or 12 support letters. Buchanan County Chamber of Commerce, Buchanan County Board of Supervisors, Buchanan County IDA.
That's all.
That's what you had? Okay. All right, I think that's something we have.
Questions from Mr. Swartz or redirect or recross?
Yes, cross,
Where are we
right.
at?
Uh, Okay. I need to unmute, which I have actually done. Okay. Um, are you confident that you have the right acreage for panel 20?
Yes,
Okay. And what is the total acreage that you're telling us panel 20 is going to be today?
260.999.
Acres?
Yes,
Okay. And the records that you've filed with the board and that we've received copies of indicate that in October 2025, your exhibit M for panel 20 said it was going to have 368.92 acres, roughly 108 acres more than you're telling us it's going to have today. Do you agree to that?
yes, and I can explain that if you'd like.
Okay. And what happened?
We reviewed the Oakwood 2 order. You have a copy of that. It's little E3. And it says, after actual commencement of coal mining operation by driving of the entry and completion of isolation of the longwall panel, the amount of gas produced from and attributed to each 80-acre unit shall be ratioed out an express percentage that the amount of surface acreage in the affected 80-acre drilling unit bears the total surface acreage contained in the entire longwall panel affected such 80-acre drilling unit. Then prior to actual commencement of coal mining operation by driving up the entries and completion of isolation of the longwall panel from the increased density of the wells shall be produced from the 80-acre unit in which the well is located. We included the development on the prior applications due to this saying isolation by. We just shrunk it down to the block of coal to match what the board had approved.
Are you familiar with the fact that Coronado is behind schedule in terms of mine development?
Yes, they have, 2 phases open up in their mine and they are managing market conditions, yes.
Are they roughly 9 months behind schedule?
Think so. Don't know for
Okay.
sure.
Is Coronado talking about mining 2 short north-south longwall panels before they get to panel 20?
They are exploring, full development of their reserve, yes, sir.
Okay, and if that happens, isn't it a fact that they would not be starting mining in panel 20 until the first quarter of 2030?
It's not what I got a text message from a Coronado representative today. He said January of 29. So
So they're gonna make up that difference, huh?
that's what the text message said. He
Okay.
could come over here.
But you understand that the plan is to move south after they finish 19 and do 2 north-south panels, which are out of our mapping right now, but there's an exhibit floating around somewhere with that map on it, and Mr. Bull testified about it. Do you remember seeing that exhibit?
I do, and yes, mine plans are always subject to change.
Okay. And would you agree that the mine plan for 20 is not final?
It's provided to me as good as 1918 is from Coronado. So yes, it's as final as I know, provided by Coronado.
Well, they've mined 18 and they're mining in 19, right?
So they are establishing development, correct?
Well, that's mining, correct?
I'm going to object to the relevance, and it's just getting argumentative at this point.
He's just told me that he has confidence in his numbers on 20, and and then he's arguing with me that it is reasonable to assume, actually, I take that back. He said that it's no different than the estimates for 19 and 18. And I'm suggesting to him, well, it is different because there's mining there. And I just want him to answer that. Is there mining in 18 and 19 right now?
Yes, they're developing those panels, yes.
Okay. And to do mining, you need to have a mine plan filed with the state.
That is correct.
And you can't mine on projections.
They want to rephrase that. That's not a clear question.
Okay. Is there something in coal mining known as mine projections?
Yes,
Okay. And can you take a mine projection and tell the coal mining agencies, we're just going to use our projection maps, not our mine maps?
yeah.
You can't.
Yeah.
Okay. What's the difference between a mine map in terms of detail and a projection map?
One's a future mining and one's a current or past mining.
Okay, let's look at a portion of your application here. Go to page 18 of your application.
Okay.
Do you see that?
I've got it.
Okay. And would you agree with me that the red and green lines, which represent the entries on either side of the coal barrier blocks, are projection maps?
Yes.
Okay, then let's take a look at our application for this unit E37 and look at the map. Okay, can't tell the date of that. I thought it had a date on it, but on the portion from the coal company, but I don't see that. If you compare the actual mine maps to projection maps, they are much more detailed. Would you agree?
Going to object to the relevance again.
Where we're going with it, Mr. Schwartz, I'm not following you either.
In terms of trying to calculate acreage.
I think we can all agree that if the acreage changes significantly, you have to come back in front of this board and represent your estimates and your percentages of payment. Is that not true?
Okay. I think we're agreeing to that. Okay. I'd just like, rather than go over cover the same ground with you again on your exhibit M, I would just like to incorporate your testimony and my cross-examination from the prior unit. And I would also like to incorporate Mr. Ball's testimony with regard to his analysis of the difference between carbon credit revenue and production and sale revenue. Let's see if there's anything else. Oh, CNX has a lease in tract 4, correct?
Where you at, sir? So,
I'm sorry.
what page you on?
Okay, I think it's page 11 of your application.
Page 11.
Actually, page 10 at the
Page
very
10.
bottom.
Yes,
Tract
tract
4.
four.
Okay, and then if we go to the percentage there, it says that is 20 acres out of the unit, right?
Oh, yes, 20.459, or equivalent of 25.574%, sir.
Okay, and then if we look at page, let's see here, page number 12, Buchanan Production has an interest in tracks 1 and 2, right?
Cannon Energy Company, yes.
I'm sorry, yes. And those in panel 19, just adding them in my head, we're looking at about 7.4%, right?
Yeah. But,
Is that correct?
yes,
Okay, and then estimating and your estimates with regard to panel 20, it's almost 11% between the two tracks, right?
correct.
And then if we go to track 4, which is the lease track that Pocahontas Gas has, we're looking at roughly 2.5% in 19 and roughly 3.75, well, 3.75% in panel 20, according to your calculations.
Correct.
Okay, that's all I have, Mr. Chairman.
Can you redirect?
I don't know if you have any, but I just want to incorporate Mr. Hess's testimony from after Mr. Ball testified and on the car. I don't want to forget to incorporate that. Did you have anything to mention?
One question on Rogers 426.
Sir,
That's the well that y'all, frac well you have right now.
yes, sir.
Once the longwall panel is isolated and then found out, will you continue to operate that?
Yes, that's intent. Yes, sir.
Okay. And just, I think we've covered this at some point in the past, but so that frac well right now, it extends below the seams that will be longwall
Extends
produced.
into
Right?
P1.
And so what's going to happen? You said something about you're going to seal it at a level or something.
Yeah, we've discussed it. Coronado will seal it 50 feet above and below their mining operation so that they can pass the miner through and continue to produce.
Okay. And so then after mining, you anticipate that gob gas will then percolate into that well.
It will be subsided likely.
And that's what you're going to be producing henceforth. right?
Yes.
Okay.
Okay, questions for the board?
With the caveat that they would come back to the board with the new percentages and participation. But other than that, I'm fine with that theory.
Just a couple of questions for you, Mr. Hess. Looking at these applications we're looking at here, the E39 and F39 are both voluntary units of Pocahontas Gas, looking at your exhibit 14 there. So under that scenario, is it fair to assume that those wells would be drilled by Pocahontas within those panels? So, and this applies to both of these applications looking backwards, but this will just be more of an observation if anything. You know that you're not going to drill those wells, that somebody else is going to drill those wells pretty much at this point.
And
So those costs that they presented and the costs you presented are close but different, correct? So whoever prevails on these units at the end of the day is going to have to revise their costs to reflect who's doing what at the end of this, all being said and done. Is that a fair?
These are cost projections.
Yeah, so this is a cost estimate, but they're going to change based on who becomes the operator
Likely, yes.
of these panels. So that'll be a fair representation to anyone who wants to participate at that point in time.
Correct. And if we're reimbursed by the coal company, we will credit wells to that.
Okay, so that was gonna be one of my other questions. You've mentioned that a couple of times. If you prevail, that you will come back before this board at that point in time. You know, you'll have to come back at that point in time and revise all your cost estimates again for that also. Okay. Regarding the carbon credit payments, I just want to clarify, and I think we've asked QRoc to put it in their applications also. They typically get paid on an annual basis under the carbon credit. Most of those things, and maybe those other entities that you've talked about, I don't know what their payment schedules are. I think the board was going to want to see in this application, if you were to prevail, a revision that says that these payments will be made on an annual basis, so many days beyond when that settlement with the company is made.
It is a
With the
sequence in the
so
market.
that an interested party knows not to expect a check every month, because you're not going to pay it on a monthly basis. You can pay it on an annual basis if that's the case.
Yeah, absolutely. Payment schedule for all markets, yeah, as they're determined.
I have a question here. Go ahead and ask your question, and I'll figure out the other ones.
The carbon credits. When you make your applications, takes a long time to get those approved.
I don't think so.
Oh,
Not 6
okay.
months. We've been in communication. We've already been talking to CARB about this project,
Okay,
and we're well down the road. So, yeah.
so if it only takes you 6 months to get your application, there won't be any delay in payment then, that's
And we feel like more than accommodating that with the lead time of money.
okay. So how long have you been in negotiations with, on trying to get the carbon, for the carbon credit?
Well, we got projects in Kentucky, so over 3 years. For me,
Okay.
as long as I've been in position.
But I mean, negotiating for the Virginia,
Oh, Virginia, over 8 years.
18 months. So you feel like that's
They're aware of it. They feel comfortable with it.
pretty, expected to finish quickly.
Yeah, once we get the operators, we can formally apply, but they're aware of the process. Got communications on
You say once you get a unit operator,
once we're awarded the pooling order. That'll be
okay, then, but Diversified will be doing all that.
correct.
That's all I had.
Thank you. The last comment I had, viewing these applications and competing applications, there are some slight differences in the track identification and the acreages with each of those. They're both certified by land surveyors. This board's not going to contest those. The prevailing party, whoever that is in these applications, their payments will be based on those that are in those applications. If the other side doesn't agree with those acreages, their remedy will be in circuit court if there's a dispute over land. So everybody understands that. But we're not going to get into any of this, who's right or who's wrong on these acreages. Okay, I think that's all I had. So at this point, I think we're ready for a summation from the parties. I don't know who goes first. At this point, we've got 5 applications here that I guess we're going to summarize.
Mr. Chairman, I'll go first as the landowner lessee co-op. This board has been very patient with all of us. We simply want to get paid, and we want this worked out in a fair manner between these companies. We want the board to protect correlative rights. And when we look at competing operators, we see that Diversified doesn't have any constraints with respect to operations on our surface. And it seems like it's a little bit strained for Pocahontas to be able to comply with the requirements to be defined. They're going to have to do horizontal drilling or whatever, but Diversified doesn't have that constraint. And they, as you can tell from the maps, the mining's going deeper and deeper than Diversified's lease. The other thing we notice is there's more money, it seems, for the stakeholders with Diversified. At least testimony indicates that. And frankly, there's a basic fairness there. They talk about marketing for higher rates. They also talk about reimbursements and credits. We're not hearing that from the other side. And so as a property owner, that's important in considering which of the two operators. And of course, we're biased. We're biased, but board should be in one respect when you have competing operators. If you look at the pooling statute 1620, you know, that it refers to an existing lease there. It is something that is not a fly-by-night lease that we're dealing with here. We're dealing with an established lease. It's been around 20-some years, and there's been production on it. And people that have it now are very capable of producing. And in selecting an operator, we think that the board has to, under 1623, C3, they've got to designate an operator who's authorized to drill and to operate the well. The board would honor an existing lease. And that's important when you go into an area and there is an existing lease and there's a lessee with operational rights, then they ought to be given deference. And those factors should be considered by the board. We just wanted to address that to you. You've been very patient. You've listened, and but I think the simple argument here that I'm making before you today is scale. You got to weigh which operator. I've given you reasons to weigh it toward Diversified. We believe in that. That's why we're here. Thank you. Thank you.
I also appreciate your time. Not all of you have been here for the last 10 months, but those of you that have, it's been educational. It's been exhausting. I've learned a lot. Not without some frustrations, I admit, and I know you felt the same way, but it's been very, very exciting as a lawyer to handle some of these new issues. And so I appreciate your patience with us. I didn't know Diversified before last year. I think I may have received a royalty check from them for like $1.50 one time. So I'd heard of them. But I can tell you that I've been very impressed with this team. It's fine. They have appeared at every hearing. Some of these guys have appeared in person at every hearing. Todd Tetrick is the executive vice president. He's a high-ranking guy with Diversified, and he drove a long way to get here. This company is dedicated to our region. They have invested in our region. They are seeking grants to develop the city. They're working with the town, the county, APCO, Coronado. They are doing everything that you would want a good community citizen to. And they have a tremendous amount of experience. They have 57,000 wells that they're operating versus CNX. They're not the worst company in the world, but they got 4,500 wells. So you've got an outstanding operator here that wants to become involved and has purchased a leasehold. It's not all of it's on this plat, but they've invested a lot here. And they want to start working with their lessor to develop the properties and do what they invested in. And I hope that you will give them a chance to do that, because you'll see that they are proactive about issues. I mean, we've made mistakes, including me at Charity. And these guys have made a couple too, but we have worked hard to correct them, and I hope that you have seen that. They will be an outstanding operator for you guys, and they will be an outstanding operator for interest holders. And so if we have to come back, that's good news for charity, because you'll get to charge for trips if they have to revise some cost, but, I don't know for sure how much more I'll see. So I wanted to say those things. I created a list here. I did it before the evidence came in, so I was kind of guessing, but if you don't mind, pass it out. Kind of did a side-by-side comparison of how you might look at the evidence and weigh things. And I broke it down into several things. I'm not sure it's in a particular good order. Surface rights is the top. Clearly on E37 and F36, particularly E37, because F36 is not going to have any cobwebs, right? It's going to be very difficult for CNX to develop guide wells in Channel 20, where basically they don't have any surface rights. And if Mr. Schwartz wants to do a kickoff well, it's going to have to be at this angle right here and travel for a mile. I mean, there's just no way. So you got that problem. We don't have that. We've got Rogers 426. We've been pooling and operating this well, as has our predecessor. This is our home turf. It's right beside 36E, 35E, and 34E, which are all voluntarily pooled units, which gives us a great majority in that pampa. Simply out of efficiency and smoothness, it just makes sense to let Diversified be the operator of 37E. You avoid this, we're going to be operating 426, even when it starts producing alpha. So we're going to be an Oakwood 2 God producer. And it just doesn't make a lot of sense to have two in the same unit. I don't think you can, based on my review of the statutes. The whole Gas and Oil Act and the unit framework is designed around one well, one unit, one operator. That has been massaged so that we now have more wells, particularly for times. But it just makes a lot of sense to have one there, and a guy that we know is going to be a guy to operate already. 36E was before the board last time, but Diversified withdrew that. And I think that's important to remember, because remember what they said last time, they were only there on 36E initially because there was that little corner. They thought they needed to know how to pay it. Well, the same is actually true on 37E right now, right? It's the same situation. Nobody's looking to put in a guide well up in the northern part on panel 20 of 37E. See, Pocahontas Gas just wants to know who to pay. We know that's not really an issue for them, though, because they relinquished 36E. They figured that out. Same thing's true on those short holes down there. They've been producing those and paying those without any pooling. So the notion that Pocahontas Gas, needs to pool is belied by their behavior in releasing 36E and making payments on some other things. I'm not sure, but I think it may be premature. Mr. Schwartz made a point today to try to suggest that panel 20 is not going to be fine for 2031 or something. I mean, way off. Anyway, back to my list. We have the surface rights on 37E. Clearly they don't. Clearly they're never going to put in guide wells. And the problem is, if they're successful, now they plant their flag on 37E, even though there's no wells on the horizon. And it's, it should be our unit because we own so much more of it than they do. We've got 77% of it. They got 22. Costs of drilling wells. I know you elected not to hear about reimbursed costs, and I respect that. But we did testify, we're not going to double charge any of the interest holders. We're not going to collect money from Coronado to pay for the cost of well construction and then turn around and charge the people for another whole set of the same costs. We're not gonna collect $700,000 from Coronado, build a well, and then turn to the people we pull and say, hey, cop up another $700,000. We're not gonna do that. And that's a huge cost savings to people that we pull. That's a huge benefit to the relative rights. Conversely, we're gonna do a better job generating revenue. You heard today, we're going to be taking advantage of a more profitable cash flow arrangement through what is a relatively new technology, which is the carbon credits. We're going to be earning nearly twice as much as CNX, and we're going to pay twice as much in royalties. So you've got, if you're hiring someone to run your restaurant, you want to know how much you're going to make me and how much you're going to cost me. We're going to make more and we're going to cost less. So we get the check boxes for that. I feel like I'm now talking longer than I meant to. I guess last time around there was I guess proper questions about who's gonna, who can manage this stuff better on the ground. Reality is on short hole gas, CNX, Diversified, they're not gonna do a whole lot, right? It's Coronado putting everything in. They're putting in the short holes, they're doing the transport underground, they're bringing the gas to the surface. These guys are gonna plug up to a pipe apparently. So there's not a lot of, company specific know-how there. But each of these companies is sophisticated enough to manage that. But we certainly are, so we can handle that no problem. Same with the guy wells. I think that's everything I wanted to say. Again, appreciate your all's patience and attentiveness. Thank you.
Thank you, Steve. Mr. Schwartz?
Thank you. Kelly, could you put up the sort of summary exhibit with regard to all these units? Okay, I'd like to start with this. We've been arguing today and in February, well, actually now for a year, but we really didn't have hearings until February and now, about 18 East panel, which is to the south of this exhibit, and then the 19 East panel, and then the 20 panel, which is not really mapped at the top here. So the units that we're talking about are from E36 to E40 and from F36 to F40. I'll start with a comment on E36 with regard to Mr. Street's argument that we gave up on that. I made a decision before the hearing that the 1 acre that's shaded in dark there was not spending 2.5 hours of time arguing about. We withdrew that permit. But I didn't hear Buchanan saying, don't pay us. So the reason we withdrew E38 was Buchanan was willing apparently to take the money, and we will pay them their pro rata share of the production from the 19 panel on that 1 acre. And I just did that as an expedient move to try and finish. I suggested if I hadn't done that, we wouldn't be finishing today. Now, where do we stand? We have competing pooling applications on E37 that we've heard today. And then we have a standalone pooling application from Pocahontas Gas on E38. So there's nothing up against that. With regard to F36, we have competing applications. And of course, that unit, everybody said we're not drilling in that small piece. And Coronado doesn't want us to drill there. With regard to the rest of the units then, in the bottom row here, the F row, we have a pooling order from this board appointing Pocahontas Gas operator, in F-37, another pulling order in F-38, a voluntary unit where we have 100% of the interest in F-39, a voluntary unit in F-40. So the only issue in that row is what to do with F-36. And the F-36 unit it needs to be, the Pocahontas gas pooling application needs to be approved in that unit. The numbers, and we went over Exhibit 1, and I'm not going to revisit this, but the participation numbers are all wrong in the F-36 application that Diversified has filed. And there is no warning to respondents that they need to know that if the board pooled F-36 based on Diversified's pooling application, none of those people would have an opportunity to participate in the panel, because all the other 4 units in that panel are operated by and funded by Pocahontas. And there's no indication in that application that, you know, your participation is contingent upon the outcome of a couple of appeals. And if you want to participate, you need to have that unit pooled by Pocahontas Gas. So with regard to F-36, I think it's a no-brainer that you really do need to provide that Pocahontas Gas is the operator and pool that unit so people have an opportunity to participate in the entire panels that are affected by E36. Mr. Street used the expression fly by night, and I'm not sure, I don't think he's used it to say that Pocahontas Gas was a fly by night operation. I think he said that Diversified was not a fly by night operation. But I will say that their reliance on how many wells they have nationwide and projects or not having projects or permits in Kentucky, their reliance on that is not necessarily something that we should take. You will recall that Diversified was required by this board's rules, printed, clear, to file for change of operator in February of 2025. They didn't do that. They didn't file, until my recollection is, a petition until May or June. Months went by. And then it took them until October or November to get out the appropriate notices, to get that squared away, to just change operator.
Jack, that's not in this case.
Well, you were arguing, sir, that you were a highly competent, your client was a highly competent operator.
Based on the
Was
evidence.
Okay, and I'm talking about the evidence, and you don't want to hear it, but does a competent operator do that? In addition,
There is no evidence in these cases about what you're talking.
I think the board knows there is, so I'm not going to pursue it further. In addition to dropping the ball on change of operator, we have had one continuance after another this last year, predicated upon requests that Diversified has made. The most recent continuance was all of their numbers to allocate money to royalty owners and people who might participate in E37 and F36 were all wrong. So we got a 2-month continuance so they could go back to the drawing board and correct all of those numbers and remail to everybody. And to show what's going on over there, they changed the acreages in panels. And it never occurred to them that that would change the percentages. I mean, is that an experienced operator capable of managing coal bed methane projects in Virginia? I think it's an issue you need to think about. We've talked about infrastructure. And we've had a lot of discussions and testimony. And basically, my take is we're hearing from Diversified that they don't have sufficient infrastructure to jump into this market with both feet on the ground and start producing gas unless they flare it. They don't have sufficient infrastructure that they inherited from Summit to enable them to transport substantial additional quantities of gas to sales points. So their choice, at least until they do that, if they ever spend that money and do that, is to flare. We've offered testimony today in response to an argument that we heard for the first time today, that it was so much more beneficial to rely on carbon credits, on energy, on attributes than it was so much more beneficial than it was to just produce the gas and sell it and pay royalty. Josh Ball came in here, and I think the takeaway from his testimony was 2 or 3 years ago, Pocahontas Gas undertook and assigned to him the task of determining whether or not it would be financially advantageous to convert all of their production that they currently sell to flaring. And you heard his testimony about the timing, about the costs, about the requirements of capital, of involving third parties in that. And you heard his testimony that as a company, it was determined that that was not economically the best solution, not only for Pocahontas Gas and CNX, but for its royalty owners. I mean, his analysis, and it's the only chart you've got, shows that it's 300% better to go with the, let's produce the gas, let's put it in a gathering system, let's get it to a pipeline, a jurisdictional pipeline, and let's sell it and let's pay royalty. The other disturbing thing, which we talked about today, and in terms of how you operate, I mean, we have Exhibit M's filed that project 5 wells in units F37 and F38, which have been pooled by this board, in which Pocahontas Gas is named the operator. And, you know, unless Diversified wins their appeals, they're not going to be able to drill any wells at all in the F row. And that's not disclosed in what they sent to the respondents, to the people they were seeking to force pool, in any way, shape, or form. Now, with regard to the E-row, I've already told you why I punted E36, and that was to save time. With regard to, I've just lost my picture here. Looking at something. I don't know what that is. Trying to get back to the screen. Let's see here.
Brad, you may have a screen up on Twitter.
Yeah, I don't know what's going on. Well, I'll just continue on. Here we go. Okay. With regard to the surface rights argument, we have been drilling directional wells, and I know that the division knows this, for years. Directional wells accomplish several things. You can drill multiple wells and disturb a limited amount of surface because they can be drilled from the same pad. Directional wells also, as we've been talking about in this instance, allow you to drill on a surface that you have rights to use and deviate the well to find a bottom position that works for a coal company. We're not.
Mr. Schwartz,
Mr.
Yes,
Schwartz, he's objecting to your discussion regarding deviated holes because there was no evidence presented on deviated holes.
what do you mean? We've been arguing about it all day today.
Want to restate your objection?
that what he is now testifying and trying to introduce facts and evidence that's not before the board. He didn't present a witness that talked about those sorts of things. He's trying to supplement the record with his own information, and that's just not really fair or appropriate.
Everybody in this room knows about deviated holes. I'll just withdraw that question and move on. The I think the last thing I want to just summarize and wrap up with this. If you look at the quality of the documents that you've seen in the course of the last year, if you think about who seems to understand the rules and regulations and the code and seems to follow them on a regular basis, and who has the infrastructure and the people in place with experience to do this, I think just from those three standpoints, you really need to grant the E37 application, the competing application of Pocahontas Gas. Obviously, there's no application from Diversified for E38, so that's a lot easier. With regard to F36, you've heard my argument with regard to failure to disclose all sorts of things to the respondents, and in that instant, and also you can see from the map, it makes no sense to not have Pocahontas Gas be the operator of F36. Lastly, I appreciate the time and energy that all of you, staff and board members have invested in this. I'm sorry that I can't attend these hearings in person, but I have personal issues that prevent me from doing that. I wish that I could, but it's not intended to be an affront to you. That's not worth the trip. But I appreciate you allowing me to sort of finish this project by appearing remotely. So thank you for your attention, all of the effort you've put into this, and your consideration of me and our arguments here. Much appreciated.
Thank you, Mr. Schwartz. Ms. Cooper, just want you to chime in and make sure that I haven't missed any procedural matters that we need to take care of along the way
No, I
today.
don't think so.
You've been silent,
think
so
you're-
I hope I was
You're doing great.
following what I need to do, so. Okay, the second question to you is, are you available to go into closed session with the board now, or do we want to reschedule that for another time?
I could do a very brief closed session.
I think it would be very
But
brief.
Okay, you
We
think
can
it'd be very
decide
brief?
how
It would,
to move forward. Okay.
Okay.
So this time, I'll ask the board to consider a motion to enter into closed session to allow us to discuss the following subject matter. Meeting will be a legal consultation for the admissibility of evidence presented during the formal hearing to determine which may be considered when the board is forming its decision. I have a motion to enter into a closed session. Do I have a second?
Second.
All those in favor say aye.
Uh,
Aye. Any opposed?
Abstain.
Two abstains. Okay, so we're gonna go into closed session. We'll have some discussion with the Attorney General's office here to determine where we are and timing of everything, and then we'll hopefully be very brief. And we'll come back and inform you where we're at and close the meeting from there. I think we have to go to the other room or 211, okay. Here, get Ben to get to. Get Ben. Okay, Ms. Gilmore, will you provide us the exit poll?
Each person needs to respond yes, no, or abstain. To the best of your knowledge, did the board restrict its hearing, discussion, and consideration in closed session to only public business matters lawfully exempted from open meeting requirements under this chapter, and only such public business matters as were identified in the motion by which the closed meeting was convened? Mr. Sutherland,
Yes.
Mr. Jansen,
Yes.
Mrs. Gibson,
Yes.
Mr. Cochran.
Yes.
Okay, we're back on the record again. At this point in time, I'm going to call each of the 5 petitions that have been part of this formal hearing, and we're going to render a decision. After a decision today, then there will be a written summary of the decision provided to the applicants within 30 days, and that will be the timing for any appeals from any parties that wish to make. Are you clear on that? The first item, item number 5, a petition from Pocahontas Gas for cooling under Oakwood Coalbed Methane Field number 2, unit E38, docket number VGOB 25-0715-4317. So I'll call for a motion to approve or deny this application.
Motion to approve.
Do I have a second?
Second.
At this point in time, we'll poll the board for each of their decisions, along with a brief decision why they made the decision.
Mr. Owens,
Abstain.
Mr. Mullins,
Abstain.
Mr. Jansen,
Here. Right page here. Okay. I vote yes for approval of this petition based on the experience, or based on the evidence presented in the application, based on the resources described by Pocahontas Gas to be able to produce this unit, based on the history of operations, based on the infrastructure they have in place, and based on their majority position within that unit.
Mr. Sutherland,
I vote for approval also based on the similar reasons Mr. Jansen gave.
Mrs. Gibson,
I vote approval and basically the same reasoning.
Mr. Cochran.
Yes, same reasons.
Okay, so Mr. Short, do you have approval for that docket item? Next item is a petition for Pocahontas Gas LLC for pooling on Oakwood Coalbed Methane Field number 2, unit F36, docket number VGOB 25-0715-4313. Still looking at the right one here. At this time, I'll call for a motion for approval or denial of this application. Do I have a motion?
Motion for approval.
Do we have a second?
Second.
Call the vote, please, Ms. Gilbert.
Mr. Owens,
Abstain.
Mr. Mullins,
Abstain.
Mr. Jansen,
Yes, I vote in favor of this petition. Again, for Again, based on the evidence presented by the applicant, the resources presented by the applicant to complete these operations, the history of their operations in this area, the infrastructure that they have in place, their experience in dealing with these types of operation, and their, those are the main features right there.
Mr. Sutherland,
I vote yes for approval. For the same similar reasons as stated by Mr. Jansen.
Mrs. Gibson,
Approval for the same reasons.
Mr. Cochran.
Yes, similar reasons.
So that, the motion carries there. Mr. Schwartz, you have approval for that application.
Thank you, sir.
The next is a petition for diversified production for pooling under the Oakwood Coal-Bed Methane Gas Field Number 2, Unit F36, docket number BGOB 25-1021-4322. Do you have a motion for approval or denial of this application? Do we have a second?
Yes, second.
We have a motion and a second. Hold the board again, please.
Mr. Owens.
Aye.
Mr. Mullins,
Abstain.
Mr. Jansen,
Yes, the decision was rendered based on the evidence presented today and the evidence presented in the applications, the resources of the applicant to complete this project under the terms of their application, and the lack of infrastructure in the immediate vicinity of this project.
Mr. Sutherland,
Yes on that as for the reasons previously stated by Mr. Jansen.
Mrs. Gibson,
The denial based on basically the same reason.
Mr. Cochran.
No, for the similar reasons.
So, Mr. Street, that application is denied today. Thank you. Next petition is petition Pocahontas Gas LLC for pooling under Oakwood Coal-Bed Methane Field Number 2, Unit E37, docket number BGOB 25-0715-4316. We have a motion today to approve or deny this application.
Motion to approve.
A second. Hearing no second, do we have a motion to deny this application?
Make a motion to deny this.
Do we have a second? I'll second that motion. Go ahead and hold the board, please.
Mr. Owens,
Abstain.
Mr. Mullins,
Abstain.
Mr. Jansen,
Yes, I vote to deny the application by Pocahontas Gas for the E37, correct? E37 unit. Again, this is based on the evidence presented today in this application. And the majority position maintained by Diversified and Buchanan Energy in this application.
Mr. Sutherland,
Motion to accept based on the evidence and majority.
Mrs. Gibson,
Motion to deny, based on the history, the infrastructure in place and the evidence that we have today.
Mr. Cochran.
Motion to deny, some reason.
So, Mr. Swarth, that application is denied for unit E37. The final application today is petition from Diversified Production for pooling under Oakwood coal-bed methane field number 2, unit E37, docket number BGOB 25-1021-4323. We have a motion to approve or deny this application.
Motion to approve.
Do we have a second? I'll second that motion. Go ahead and poll the board.
Mr. Owens,
Abstain.
Mr. Mullins,
Abstain.
Mr. Jansen,
I vote yes to approve that petition from Diversified Energy for unit E37. Based on the evidence presented today in the application, the resources, their history of operations in the general area, along with their experience in the majority position within the unit.
Mr. Sutherland,
Vote to approve based on the same reasons as given by Mr. Jansen.
Mrs. Gibson,
And I vote to deny based on experience in Virginia drilling and Virginia infrastructure and the evidence presented.
and Mr. Cochran.
Yes, due to the amount of ownership in that unit. Estimate cost presented.
So the motion carries. Mr. Street, you have approval for that application. So again, just to reiterate the process going forward, the Attorney General's office will prepare a written summary of the evidence presented along with the decision of the board. The board will reconvene next month at a regular scheduled meeting to vote on that written decision before it goes out. At that point in time, that will be presented, each of these will be presented to the applicants, their considerations if they need to have further action on those. Any questions, from anyone? Sure. The next item on the agenda is item number 10. The board will receive an update from the board of petition actions from staff. Any updates?
Nothing on the agenda other than formal decision. And just like to mention that the Crawford's office, all everybody knows, will probably be at the government center.
Yeah, that's on, it's on here. It's-
The May meeting,
And we are at on the 19th, right? Okay, just wanted to make sure. I know we looked at the 12th, but she said no, but I wanted to make sure.
just so everybody knows, the only item on that agenda will be the decisions there, voting on the written decision. There are no new items on the agenda.
Order breakfast for that one.
Maybe consider doing that one virtual.
That is a consideration. If we have enough members who would prefer to come in person, we can do it virtually, or we can
Virtually, yeah,
virtually.
virtually. I mean, I have no problem with
There's
virtual.
nothing on there but the decision.
Yeah.
So we'll advertise the meeting as a virtual
We
meeting.
still have to advertise the meeting.
We still have to advertise the meeting, virtual meeting. So I'll plan on just calling and going over the written decision and
And just for y'all know who were not in the closed session, that will count as one of the board's 2 allowable virtual meetings for the year. So just FYI.
Okay, final item on the agenda is the board review the February 26, 2026 minutes for approval. Can I have a motion to approve? So second. Second. Right, we have a motion and a second. All in favor, say aye. Aye. And motion to close the meeting today.
Motion to close.
All in favor, say aye.
I don't have to abstain from that, do we?
All in favor, going home.
Maybe I can be of some benefit now.